Good evening, everybody. Can you all hear me?
Yep.
If you can put your screens on so I can see faces rather than just names, that would be quite nice. Thank you, hello. Much better than just talking to a box of names. It's all right, Rimal, I know that you've got to go and have your tea.
All right, just pass me up to everybody. Thanks.
Okay, so I'm going to get going, even though we've got a few people joining as I'm talking, but I'll try and multitask. So good evening, everybody, and thank you for joining me. I'm just going to share my first screen with you. As you all know, I'm hardly the most technical, so, you know, we'll just see how it goes. Hopefully you can all see it. Sean, Cyril, can you see that? Yeah.
It's loading at the moment.
Okay. The wonders of modern technology.
It says you started show. Yep, I can see it now.
Wonderful, we have liftoff, lovely. Okay, so I'm just going to run through what we're doing this evening. So obviously we have the fantastic Sean Hooker and Cyril Thomas here to talk to us this evening. Firstly, Sean will talk to us about the property redress scheme and their fantastic new product of a mediation service for landlords. And then we'll move on to Cyril Thomas from the Property Investors Bureau. He's going to speak to us all about property education and the new scheme that he is introducing as well. So what I'll do before I pass over to Sean, first of all, is I will start with our little legal update, as I always do. So, as you all know, there was quite a lot of, what can I say, flurry of interest yesterday as 3 pieces of legislation came into force. So as of yesterday, the tenant fee ban now affects all tenancy agreements. So if you've got a tenancy agreement that has a clause in there that says there's a fee, it's now void and invalid. Obviously, this law did come in on the 1st of June 2019. That only affected new tenancies. As of yesterday, it affects all tenancies. And of course, if you're signing new tenancy agreements with your existing tenants, the deposit must now only be 5 weeks worth of rent. Yesterday, we also saw introduced the new guidance with regards to the electrical testing that's coming in on the 1st of July. And that will be for all new tenancies again. And then on the 1st of April 2021, we will see it affect all existing tenancies, so your renewals, etc. Now, if you do not abide by these regulations, the council can fine you a maximum of £30,000. So it is worth making sure that you are abiding by this. And it's to make sure that your electricity installations are up to Part P and the 18th edition level. And we also saw an update to the COVID-19 guidance for landlords and agents come out yesterday. Not much of a change on that, to be honest. There was just an introduction with regards to the rent arrears protocol that we know is going to be introduced quite soon. So that was just an idea of how that's going to be laid out. And of course, as we know, the courts are set to reopen on the 26th of June. This just means that administration of possession proceedings will start from that date. It does not stop Section 21s and Section 8 still needing to be 3 months notice. That will be reviewed as of the 30th of September. So that's everything from me with regards to the legal update. And what I am going to do now is I am going to pass you over to Sean, and he will go through all he needs to tell you about this miraculous new service that's going to solve all of your problems. Over to you, Sean.
Thank you, Julie. Can everybody hear me? Can everybody hear me?
I can hear you.
Yeah, good. Okay, I'm just going to share a couple of slides that I've got just for the brief introduction I'm going to do to the scheme.
Yeah, I'm
just I've only got 4 slides, so we're not going to be a long kind of PowerPoint, but I just had put a few slides together that just will visualise a little bit about our company and where we are. Right, okay, so that is me, okay, and I'm Sean Hooker, and I'm the head of redress for the Property Redress Scheme. Now, what is the Property Redress Scheme? We're one of the 2 government authorised escalated complaint services that all letting agents, property managers and estate agents need to be part of legally in England and in Wales. So effectively, it's like being an ombudsman, and one of the other schemes is called the Property Ombudsman. We call ourselves the Property Redress Scheme. Redress and what an ombudsman do are quite similar. Now, if we go to the next slide, please, Julie. Okay. So these are the people that we are authorised by. So for the letting agent and property managers scheme, we're actually authorised by the, I call it the Ministry of Magic, but the Ministry of Housing, Community and Local Government. So that's the government department that we are accountable to. And the bit of legislation that was passed that made it mandatory for all letting agents and property managers to be part of a redress scheme. Now, older, back in 2009, all estate agents needed to be members of a redress scheme. And at the time, that was authorised by the Office of Fair Trading, but their remit was transferred over to an organisation called National Trading Standard Estate Agency Team, which, if you've been following Julie and all the other work, all the other updates, you will know that they merged the letting agent and the estate agent trading standards to become a primary authority, and they're now known as the National Trading Standards Estate Agency and Letting Agency Team. And effectively, they are the National Trading Standard enforcement body that enforces a lot of rules and regulations regarding property in this country. Ironically, they are based in two different host councils, one in Powys in the middle of the Wales, and the other one, the letting agent one, which was set up recently, that's hosted by Bristol. So their team, are based in two different offices. I think they're quite used to the sort of home working that we've all got used to, and they're quite a small team because essentially enforcement of a lot of the property laws goes down to the local trading standards organisation. And just to add another string to our bow, under a bit of legislation which was part of the EU directive on alternative dispute resolution, and actually came in as part of the consumer regulations, that all trading bodies must now signpost their consumers to alternative dispute resolution, whether they use it or not. And there are approved bodies which are approved by the Chartered Trading Standards Institute, and we applied and were accepted by the Chartered Trading Standards Institute to provide a dispute resolution across a whole range of the property industry. And actually, what we'll come back to before Cyril actually talks about is that is why we are now offering redress to his members who are part of the property education sector, even though there isn't a specific piece of legislation that says they have to belong to a redress scheme. Now, all of this is administered by our parent company, who are Hamilton Fraser Group. And if you go to the next slide, Julie, you might recognise some of these well-known brands. Next slide, please.
Yeah, I'm trying.
Sorry. This is like not being in control of your own destiny here, but
there we go. Sorry.
Yeah, perfect. Yeah. So right, okay, we can skip through that because I pretty much said what we've done there. We've over 14,000 individual members now, so that's quite an achievement. We actually reached that last week, and the people are still joining the scheme. Some of them, you kind of wonder where all these new agents are coming from, or whether they were actually part of a scheme in the first place and they've only just realised 5 years into the scheme. But we're over 14,000. But if you look here, these are some of the brands that Hamilton Fraser runs. So those familiar with taking deposits will recognise My Deposits, one of the 3 deposit schemes that operate in across the UK. We have different brands for Scotland and for Northern Ireland. And we also run the only deposit scheme in Jersey, would you believe it? Then if you look down there, we've got client money protection. And again, this was another bit of legislation that came in there for letting agents that hold other people's money. They have to now have mandatory client money protection. And if they're not a member of a trade body, they have to source it from somewhere else. So client money protection or client money protect is a protection scheme for those people that are not members of trade bodies. Again, those people who have been tuning into Julie's shows will know Paul Champolina. And Paul Champolina founded and ran Landlord Action for 15 years before he came and liked us so much that he sold us his company. So we run Landlord Action, which is an eviction specialist and debt collecting organisation, and also a registered with the Solicitors Regulation Authority legal firm. Down there you've got our property professional indemnity insurance, which covers you for professional indemnity if you're running a business. And a lot of letting agents and estate agents actually are part of that, and it is now mandatory if you're going to run a letting agent. You'll need professional indemnity to get your client money protection and therefore be fully legal. And then, of course, the father of them all was our landlord insurance, total landlord insurance product, which is one of the leading insurance products for for landlords, specialist landlord insurance. And the other little one, Tenant Verify, we run a small credit referencing company called Tenant Verify, and we acquired that at the same time as we acquired the largest, one of the largest landlord portals, which is Landlord Zone, which is a news and landlord portal that has over 135,000 subscribers to it. So we've got a lot of fingers in a lot of pies, but you can see that the pie is all connected and it all joins up together. So if we go to the next slide, please, Julie.
I'm trying.
No problem.
There we go.
Okay. Right. Okay. Right. So yeah. Okay. Skip the one before that. The one before that was that we ran. We started doing education, Paul Champolina, and in partnership with a lady called Susie Carola, who runs the Guild of Professional Letting Agents. We provide, we were providing a lot of face-to-face education at our offices and in venues up and down the country, but our plans for this is to go and provide training online across the country to letting agents and estate agents on legal training and other qualifications that they can get. So that's another area we think is going to be, as regulation comes in, expanding. Okay, so let's get on to why we set up the mediation. This is what I'm here to explain. So we set up the Property Redress Scheme Mediation Service, and it's literally been going for just under a month now. And I can see the question you're going to be asking: why did we set it up? Well, one of the reasons we set it up was that about a year and a half ago, we started looking at mediation as an effective form of dispute resolution in the Property Redress Scheme. We were doing what was called adjudication, which is basically the parties send in all the evidence, and someone like me looks at all that evidence, and then, like a judge, makes a decision on that dispute, and then kind of sends out a paper saying this is what I have deemed has been the result of that dispute. But we felt that another effective way of dealing with disputes is to actually get the parties to try and, through a mediator, a middleman, try and come to an agreement themselves. And the advantage of that is, if you think about when you are being imposed something, we all can get very stubborn about it. And if we're told what we have to do, we pretty much don't accept that as much as if we have come to that decision and agreement ourselves. So mediation is very, very effective in bringing parties together and getting mutually acceptable results. So we started introducing that. And then a number of things happened externally that actually made us actually think a lot more about the issue in the property world. And the first thing that came out of the woodwork on that was that
we heard as I plugged it in.
Sorry, okay. That the government were looking at reforming the eviction process. Now, we're quite familiar probably with that over the last 2-3 years, that there's been a systematic kind of look at what's in England is called Section 21 eviction process, which is basically the no-fault eviction process. And effectively to look at that and to put more barriers in the way of it. The government or successive governments had been kind of looking at evidence that longer tenancies were what tenants were looking for, and that the eviction process was possibly being abused, was unfair to tenants, and really wasn't fit for purpose. So they, eventually they've decided to scrap Section 21, and that has systematically been the policy of the government through the last 2 or 3, albeit conservative governments, but of different leaders. And Boris is now committed as part of his Rental Reform Act to get rid of Section 21. And effectively then to make all evictions subject to the discretion of a court. Now, we've always had the two processes of Section 21 and Section 8, but we know the reality that most landlords, when they realise that their tenant is not paying rent and they are not going to have that money in the future, they say, really, we just want our property back so we can move on. So they serve Section 21s. Now that is going to be taken away from the equation, and therefore you're going to have a ground to raise to service an eviction notice. So this was coming in, and roughly at the same time as well, the government were talking about extending redress, which was for letting agents and property managers, and saying, well, really, why are landlords not included in the redress process? So my thinking on that was that basically, if they bring in redress for landlords, what's the most common thing that a landlord and a tenant will probably dispute over? And that will probably be something like a repair issue or something like that. So the tenant hasn't got a certain repair done in their property, and they want, they've gone into dispute. They may have even stopped paying rent, which is the wrong thing to do legally, but that's the way mentality is. If you're not getting the service, people do withdraw the payments. And these are ideal disputes that mediation can actually deal with, rather than a long 6-week process of adjudication, by which time the tenant's been living with a disrepair possibly, or the arrears of the rent are going up because the tenant's refusing to pay the rent. So that was another opportunity for expanding out the remit of mediation. And I don't need to say what happened 10 weeks ago. We suddenly entered into COVID, and that changed the picture. So we've been working on the mediation service, and actually Paul Ciampolina and myself were part of a working group on the Section 21 issue through what's called the Letting Industry Council. Now, people who haven't heard of that, the Letting Industry Council is a voluntary organisation that basically is hosted by Savills down in central London, but they managed through, remarkably over the last 2 or 3 years to get practically everybody from, vested interest from the property industry into one room or one organisation, just as a forum to talk. And it's not just a talking shop. They set up a number of working groups to actually look at various different aspects of the property market. So, for example, Kate Faulkner, the well-known property property commentator, she hosts the Buying and Selling Group for a estate agency, and there are big changes coming in the future there. Kate would be a brilliant person for you to get on the show, Julie. But we sat on the what was called the Beyond Section 21 group, which was basically realising that the government's will was to get rid of Section 21. So that fight, effectively to persuade the government not to scrap Section 21, had been lost. But the reality is what was going to replace it, and how would the new system of evictions and possessions work in the new world after Section 21 is abolished. So a big paper was commissioned from a group of university researchers. Have done a big paper on their conclusions of that. It involves things like whether there should be a housing court. And a big section of that is that if you're going to bring in a new form of evictions where a court hearing is going to be the arbiter of a reason for giving the possession, the only effective way you're going to be able to manage that is if you can bring in some protocols and pre-court action, including mediation, which will be part of that process. So, literally 2 weeks before the lockdowns was announced, the paper was finished, signed off by the working group, and was going to be published. But of course, everything went to pot after that. It's been delayed, but I was just talking to Paul Sampolina today, and they're actually going to be releasing it in the next week or week 10 days. Maybe sooner if we can get we can get all the media stuff sorted out. So as soon as that comes out, I'll let Julie know, and she can circulate it round to you, the paper that's coming out. But a big part of that is the mediation. So we'd already been working on the concept of that when COVID came in. And suddenly we started hearing all the stories of people struggling to pay rent, and the difficulties with students, with people losing their jobs, all of this. And effectively, we said, well, actually, this is a brilliant opportunity to bring mediation in immediately. Because what's on top of that, Julie's just said to you, the court's closed, the notice period was extended to 3 months, and effectively landlords were sitting there with tenants in their property, not paying rent, okay, doing their best to try and help their tenants, but really realising at the end of the day, if that tenant can't afford to continue living there, I'll need my property back. But, what's the reality now? Would it, even when the courts reopen on the 23rd of June, there will be a huge backlog. Landlord Action, for example, is over 600 cases in this pipeline. And, these are all ready to go. They're ready for hearings and ready to proceed to court. But, of course, the courts have got to open, and then there's going to be a backlog, a queue, to actually get that result. So even though you should now be still, if you want to evict a tenant, serving your notices, don't hold your breath. Your tenant could be there for quite a long period of time. So this bringing in this mediation service is the ideal opportunity now to try and go in there and deal with some of these issues before they have to go to court, to take them out of the queue effectively. And we know that property is personal. That is what I've always believed and found, that in the industry, people that care about this industry, property is personal, because you are basically, you're providing a home for a tenant, and that tenant is paying rent for your your future. Maybe it's your pension, your investment, and that sort of stuff there. So the disputes that occur from property issues are not like other transactional events. They're very, very emotional. They can get very, very fractious, and people can get very, very angry. They're also quite complicated because there are so many rules and regulations, so many laws that people need to know that it's like a minefield trying to negotiate a way through that. And I'll tell you now, most tenants, even during this crisis, I'm not comfortable with not paying their rent. They're not all militant people wanting to go on strike and that. A lot of them are ordinary people that are absolutely desperate to think about where, that they might not have a roof over their heads. But they don't know the first thing about how to do this. And, unfortunately, when people are faced with that sort of situation, their natural reaction is to bury their heads in the sand and stop communicating, or feel scared of their landlord, that the landlord's going to do something to them that, so they try, they avoid, they avoid the landlord, and they avoid trying to engage to try and come to a solution. And that's where mediation comes in. What we try to do with our mediation is when you instruct us, we will then contact the tenant, and we will contact the tenant, by telephone. And if you give us an email address, we'll email them. I will try and arrange an appointment with the mediator and the tenant only to talk to them and to find out what we can do to try and help to come to an agreement with their landlord. We will also be speaking to the landlord, the mediator and the landlord. So the tenant and the landlord don't actually have to talk to each other. It's not kind of we put them in a virtual room and they have to argue it out. We are act as the go-between, and we work with the landlord to say, well, actually, how do you think we can actually solve that? And ultimately, if it's rent arrears, we'll try and come to an agreement, payment plan, which is, once it's agreed by both parties and signed off, it becomes a binding agreement between the two parties. And, it's the structure for them, to maybe pay a reduced rent for a period of time, and pay that back over a deferred period, or whatever the agreement that the parties are comfortable with that works for them. And that document then becomes the blueprint for them to try and continue on with that tenancy, for the landlord to get income in, and but the tenant not to lose their home. Now, of course, agreements can be made and agreements can be broken. So what happens if the tenant doesn't abide by the agreement? Well, your right to go to court is absolutely intact, and actually, in fact, is actually strengthened, because as part of this the COVID issue, and again, this was something that's been in the pipeline for quite a while. They've been looking at what's been called pre-action protocols. Pre-court action. And that is basically, although you've got the right to go to court, when you go before the judge with your possession, he now, or she now, can actually ask you to demonstrate what you have actually done to try and resolve this issue prior to them actually going to the court. And he can take that into consideration as part of the hearings. So pre-action protocols will mean, that landlords will have to try and demonstrate that they've tried to engage with the tenant. Mediation is a perfect way of doing that. Done risk assessments on them, maybe looked at, helping them with getting benefits. It's amazing the number of people now that are claiming universal credit that have never claimed it in their lives. Now, if you think claiming benefit is an easy job to do, you try following the forms, the online forms that you have to actually fill in to actually qualify for it. Not least, the other delays and problems you've got with universal credit. But it's actually in the mutual benefit of a landlord, if their tenants are entitled to benefit, to try and help them to get that benefit, because that will then be another form of income that will help to pay their, to pay the rent. So that's basically the process and how it works. And if, for example, we don't get in contact with the tenant, we will produce a document demonstrating that you have tried to engage with the tenant through a mediation service. We will provide you with a document that you can then go to court when you get a hearing and say, look, we did our best to try and fulfill the pre-court action, and we tried to engage with the tenant, but they weren't cooperating. And of course, we will also, you will also have a document if the tenant has agreed to something and then defaults on it, that you can also demonstrate to the court that they have defaulted on a binding mediation decision. So it works every way. So we've put together the scheme there, and it's done in 3 stages. And there is a charge for each of those stages, but it's not a prohibitive charge. So for the first engagement, where we try and contact the tenant, would be £125. Then after that, it would be £275 for a mediation, and then there's a small charge at the end of it for drawing up the documentation. Afterwards, I think that's £100 for doing that. So if you go through the whole process, you're looking at around about £400 to £500 for the service, which £400 or £500. Oh, that's £400 or £500. Blimey! But if you think about it, how much money that you would potentially spend if you had to go through a full court process, including instructing bailiffs. And then there's the elephant in the room. For every day that property is occupied by a tenant that doesn't pay your rent, you are not receiving your income. For every day that tenant remains in that property not paying your rent, it's another day that you can't put another tenant in that will pay that money. So anything that will help you to get that tenant out quicker, if that tenant has no intention of paying you any money, the better. Anything that can help you get some of that income and mitigate some of your losses is going to help you. So in the grand scheme of things, you could sit and wait until September beyond, or you can try and engage and try and get a solution to your problem as early as you can. And we are finding that the success rates for the mediations are surprisingly high. Over 70% of the cases we've already done that have gone through to mediation, we have come to settlements that both parties are satisfied with, and there is income coming into the landlords from that. The engagement, we are very thorough in trying to actually contact the tenant, but there will always be ones that are not going to be contactable. But in the grand scheme of things there, this will strengthen your position when you do actually go to court. So that's, where we are at the moment. So one of the questions that Julie asked me before we came on live was, well, how's it going? How many have you actually got going through at the moment? Well, I can tell you now at the moment, and this was updated today for me, I've been told that we are actually dealing with 150 cases at the moment, over 150 cases. Now, a good proportion of those, however, are coming from another source, which is another COVID-related situation. And that is, we've been engaged by one of the rent guarantee legal expenses firms to deal with their cases. Now, I'm going to be careful what I say here because it's all subject to ongoing legal wrangling, but unfortunately, a lot of the providers of rent guarantee insurance have excluded COVID-19 related rent arrears from their policies. So they're effectively saying that this is not a notified disease, and therefore they are not obliged to pay out on their rent payments under the rent guarantee policy. However, they are still obliged to provide the legal expenses cover in order to take, to allow the legal action to be taken against defaulters in the property. But they've come to us and said, look, actually, they believe that with the COVID situation and the closed courts, that mediation could help mitigate the losses of both themselves and their landlords. It would be, we're not involved on the rent guarantee side, the rent guarantee side on that at all. So we're only doing it on the basis of the legal expenses cover. However, it would be very interesting, and we've been upfront with them, it would be interesting to see if the government or the courts, I think it's the CMA, are looking at these policies to see if the insurance policies are that they, these insurance companies are entitled to void their policies on the basis of paying out rent during this crisis. But that's another argument at all. But we're actually picking up a lot of work through that. And again, this week, literally, we have opened up the mediation process to Scotland. Now, as people know, Scotland is a devolved administration, so it's got separate rules to the way it deals with things. They already have banned false evictions up in Scotland, and they run a different process using a property tribunal. And the property tribunal up there is also going to be introducing pre-action protocols, which mean that you're going to have, in Scotland, have to undertake things like mediation and other stuff before the courts will proceed with their cases. So we just opened that up this week, and we're getting a lot of interest in that situation. In terms of the pre-action protocols, it's like everything else when you're waiting for government. Well, in this case, it's actually the legal services, the courts. The actual pre-action protocols have not actually been published yet. They're still a work in progress. But all the experts I've spoken to, and I think Julie picked up on this in one of her updates earlier this week, it will be very similar to what's in place for the social housing sector. So we are not predicting that there will be anything different in terms of the requirements for the private sector than what is imposed on the social sector, which is, again, assistance with benefits, help doing a risk assessment on the tenant for their vulnerability, engaging in mediation, trying to negotiate payment plans. I think that is as far as I will go at the moment, and because that's quite a lot of information to absorb.
Sorry, I couldn't unmute myself then. That was right bizarre. Thank you very much for that, Sean. Has anybody got any questions with regards to what Sean's gone through already? Everyone is very quiet out there. Have you all gone to sleep? Goodness, you can pop it in the chat box if you want to. Okay, well, I'm going to start with a few questions that came through before we went live. The first one is basically, can anybody use the service? So I had someone say, do they have to be a member of the property redress scheme to actually use your service, or can they just contact you because they've got a problem with their tenant?
No. This is actually not connected directly to the redress scheme that we operate under license. This is a totally new service that is open to anybody, to be honest. So if you are a landlord or a letting agent, you can contact us and use our services. So it's not restricted to the property. The only advantage of for letting agents and members of the property redress scheme is that we do have a couple of nice deals for them. That if the mediation fails for whatever reason, they can get a free notice served by landlord action, which is one of the benefits of being part of a bigger family, is that we can offer that over on that. But no, effectively, it's open to anybody that's in this situation.
Fantastic. And if a landlord is using a managing agent, so it's the first time that there've ever been an issue, and they've got a letting agent that just isn't doing what it should be doing, can a landlord use your services to sort of bypass the letting agent, even though the letting agent is still in place?
Oh, well, absolutely, because it's the landlord whose property it is and wants to get it, and ultimately will be going to court, even if they're represented by a letting agent. And quite interestingly, over the years, as the different restrictions on Section 21 have occurred, a lot of letting agents have shied away from trying to deal and organise eviction processes. There's so many rules and regulations, which I'm sure lots of you are familiar with. Anything from not protecting the deposit properly to EPCs. To now the latest one that if a charge has been made to a tenant under the Tenant Fees Act, you can't serve Section 21s. So a lot of letting agents have decided, well, do you know what? There's so much risk in this that we will pass back the responsibility of a possession to the landlord. They may still kind of try and recover your monies by writing letters, but a lot of them do say no, we won't do an eviction for you. So yeah, so if you're not happy with the way that your landlord is, your letting agent is dealing with your possession, you've got every right to take that, take it yourself and proceed that way.
Fantastic. Just had a question come through on the chat from Adam. I have a tenant who will not engage with me full stop. They keep changing telephone numbers, email addresses. The only way I can communicate with them is to knock on the door. They have arrears and periodically send me money. They will not engage with me. They will not engage with me. Why would they engage with you?
I anticipated that. And that is the beauty of mediation. As we said earlier, the situation between a landlord and a tenant can get to the stage where, the relationship has fully broken down. That doesn't mean that the parties don't want help, but they just can't kind of bring themselves to communicate with each other. And it's amazing that, you say, well, I can't get in contact with him. What hope have you got? The success rate of us actually getting in contact once they know that there is a third party neutral person dealing with it is absolutely skyrockets up. Okay, there may be a little bit of distrust on there, but when they realise that we are not kind of like bailiffs, or we're not lawyers acting on behalf of the landlord, because we are neutral, they are far better engaging with us. And actually, if you think about the process, and it'd be lovely to come back and take you through some more detailed case studies when we've got a bit more time to do. But when we start dealing there, the large parts of this are confidential between the individual parties. So a tenant can actually speak to a mediator in confidence, and divulge stuff that they don't want the landlord to know about their personal reasons and their other issues. Because a lot of tenants are wrongly, in many cases, because they don't understand, they're wrongly scared of landlords. They think the landlord's going to kick them out of the property, or they're going to, do various things to them. They're not going to do that. And equally on the other side, we engage with the landlord and deal with the landlord confidentially as well on that side there. So the art of mediation is quite effective of breaking down those barriers and actually getting resolutions where both parties didn't think they had a cat and mouse chance of getting it. So it's worth a go. But the alternative is that you wait until September to get your court hearing and your eviction and all the things that kind of can happen with that. We try to take the adversarial element out of it and try to concentrate on getting the solution.
Yeah, I mean, I have to back that up, to be fair with you, Sean. I know obviously this particular service has only been going for a month or so, but as I'm sure most people know, I used to work for the Citizens Advice, and it was really interesting to see you have tenants coming into me and they're, as far as they're concerned, their landlord is an ogre and a terrible human being and was born to be a rogue landlord. And as soon as I pick up the phone and speak to Mr. or Mrs. Landlord at the end of the phone, it's just a case of, oh, I didn't know there was a problem. So, a lot of it is a case of, I think, sometimes the tenants or the landlords can blow things out of proportion in their own experience, in their own mind. We all know that a flood is actually a dripping tap and that kind of thing. So I think once there's a new person in the middle, it kind of breaks up the animosity between people.
Correct. And you've also got to remember that, quite rightly, that your relationship with the tenant, your situation, is very personal to both of you. And you may think, well, actually, this is unique to me. But as I say, our mediators are trained, they're experienced, and they did, there's 150, cases we've already got in the pipeline there. Our mediators are dealing. There's very little that they see that they haven't seen before in some shape or form. So they know the methods and the ways of trying to engage with people. Okay, so we spend a lot of time in that initial contact to reassure the parties they have nothing to lose by talking to us. Nothing to lose. They have everything to gain, nothing to lose.
Absolutely. Just one last question that's come through. Do you have any data or evidential statistics that show the rate of success for mediation?
Okay, so as I say, you know, just looking at, we've only been operating for less than a month there, but I've done a lot of studies into mediation levels and similar mediation type schemes, and the success rate is north of 80%. Okay, now, you know, you have to caveat that by saying that, you know, there will be a number of ones where you just literally can't get off the starting block. But once you actually get that initial engagement, then it's north of 80% success rate, and with with only something like a 10% default rate on it as well. But we're working through on the systems how it actually works on this. But that's when when we looked at the initial studies. There's a lot of studies out there that you can look at the success of that. It is very, 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 very effective.
Thank you. Another question is, how long does the mediation process take? I mean, do you get to a point where your mediators feel that they are literally just going backwards and forwards in a tennis match and will draw a line under it, or will it be a case of it will just carry on going until somebody somewhere reaches an agreement?
Right, okay, well, yes, the eternal tennis match. To be fair, the process is, is quite time limited. We don't anticipate spending more than 3 hours in an actual mediation, because if the mediator can't establish whether there is a possibility of a deal in that period of time, it's probably not going to happen. So these are not long drawn out processes because there is a judgment there on the prospect of success that can be quickly established. Now, if it does take more complicated cases can occur, it may take a little bit more time to do that. Don't be fooled. This is not a long process. If the mediator knows what they're doing, they're not going to be there for hours and hours, days and days. It's not like we're trying to do the dare I say it, the Brexit negotiations.
Great, thank you very much, Sean. Does anybody else have any more questions before I pass us over to Cyril? Just watching my chat box, just in case anyone's typing. No, I think we're good. Thank you so much for that, Sean. If anybody does have any questions for Sean that they think of, like always, once the meeting shuts, it pops into your head, then just drop me a message and I'll make sure that gets passed on for you. So I'm now going to hand over to Cyril Thomas, who's going to tell us all about the Property Investors Bureau and the new scheme for accredited educators. Thank you. Cyril, over to you.
Excellent. Thank you, Julie. Can you hear me loud and clear?
I can hear you loud and clear.
Fantastic. So first of all, thanks for sending me the questions in advance. So what I'll try to do is address each of your questions in turn. So to start off with, so what is the Property Investors Bureau? What are its main objectives? They can be summed up into 3 objectives, which are to help credible property educators differentiate themselves from less credible property educators, to bring greater transparency to the property education sector, and to bring greater protections for consumers who are planning to purchase property education. So those are the 3 main objectives. And once you keep those in mind, then everything that we do is basically based on that. So as you know, in the media of recent, there's been a number of occurrences that may have, I suppose, heightened the need for such an institution, for such an initiative. I'm not going to be mentioning any names during this discussion, but things haven't changed over the last decade. There's always something going on in the property sector. The next big scandal is always occurring in some way, shape or form, where consumers may have been, I suppose, may have lost money by investing in certain education. And as a result of investing in that education, something may have gone wrong. Sometimes it's the fault of the educator. Sometimes it may be the fault of the consumer. But the issue is that the same issues keep occurring time and time again. Now, we believe that if there is increased transparency in the sector and higher standards, we can reduce the risk of such occurrences from happening in some situations, it's been outright fraud and scandal where the educator involved has ended up in prison. So that's happened a number of times. Again, I won't mention any names. And in those situations, some of the consumers have lost hundreds of thousands of pounds. A poll's just popped up on my screen. Is that you, Julie, being proactive? I can't hear you, but I presume you're saying it is you. Okay, excellent, excellent. Okay, so before we go forward, what I'm going to do is I'm going to tell you what the Property Educators Accreditation Scheme is not, as opposed to what it is. So showing you the limits that we work within and what you can not expect from us. So consumers shouldn't rely solely on the Property Educators Accreditation Scheme to determine whether or not a educator is suitable. So that basically means that you can get a lot of information from us, but you're still expected to do your due diligence. So PES, which is abbreviation for the Property Educators Accreditation Scheme, cannot protect against future issues, but can help to ensure that you can make a more informed decision today. It's also not within the PES remit to pursue property educators that have proven not to be credible. And it's not the responsibility of PES adjudicators to forensically research each property educator that has been accused of some form of scandal. So once you get past that, then we can move on to the reason why PES exists and the reasons why it can be of benefit to the industry. So this is moving on to Julie's questions now. And she sent me several questions which I believe are going to be very useful to your members. So Julie, if I don't answer the question in full, if you think that there's more to it that you want to know, you can cut in at any point in time and ask me for more information.
Okay.
So the first question is, what was the key factor or reason that made you want to address the property education industry? So the Property Investors Bureau, which is the body that runs the PES scheme, it's actually been several years in the making. It's not as a result of any recent occurrences. And the Property Investors Bureau is organised by the team that run the Property Investors Awards, which has actually been going in one guise or another for the last 10 years. So we have roughly around 500 people show up to a venue in central London each year to hand out awards to those who excel in our industry, the leaders in our industry. So the PIA recognises excellence in property investors, but the issue we have there is that every year we had quite a few people coming to our events and we'd be in communication. We've got over 20,000 people in our database for the Property Investors Awards. And naturally you have people who ask you, well, actually, I'm now inspired by what I've seen at the awards. How do we become like those people? What do we need to do to get there? Who do we go to learn from to increase our abilities to become potential winners of the awards? Now, it's a bit difficult to give personal recommendations. I don't know every educator in the industry. And actually, I'd be quite reserved in regards to giving my personal opinion about educators because they change as well. An educator that's good today may not be good tomorrow and vice versa. So I decided that the Property Investors Awards team would be well placed to create a scheme or a body that would be able to help property investors to make those decisions in an unbiased way, in a more objective way. And that's when we started putting the scheme together. We also wanted the scheme to increase consumer protection, but not increase consumer protection by regulation because we are not a government body. Through self-regulation, because through self-regulation you can do so much. You can change the culture of an industry through self-regulation. So if you raise the standards in the industry by maybe 5 or 6 of the key players signing up to a code of practice and ensuring that that's a minimum standard for their services, that has an effect, a knock-on effect to those that are coming after them, and those that are operating on the same level as them. So all of a sudden, when comparing one person's education services with another person's education services, you're going to be able to say, well, actually, this educator has been transparent with their terms and conditions. This educator has been transparent with their money-back guarantee. This educator has been transparent with their pricing structure and what to expect when you go on a taster session. Whereas the other educator, you just don't have the information. So where would you be most comfortable to spend your money? So Julie also asked, who's backing the scheme? Who's backing this initiative? Who's involved with it? There are plenty of people now backing the scheme and involved with the scheme, including the lovely Julie. But I will mention a few organisations that you may know already. So we have dozens of property educators who are staunch supporters of the scheme. The Property Redress Scheme, obviously, they are our chosen redress body. So we actually pursued them because we know that they do very good work already in the private rental sector in relation to property agents. Howard Kennedy LLP, they're quite a large law firm based at 1 London Bridge. Horner Blakey, another central London firm, but they specialise in insurance. Shawbrook Bank, most property investors should know of them. Lendwell, a newer player in the industry, but they are very keen to see standards raised in the industry. A number of online forums, including bodies like Property Tribes, Property 118, and a number of the Facebook groups that's around. Now, I could keep going on, but you get my gist. There's quite a few people out there wanting to see this succeed. The next question was, why does it matter that the property education industry needs to be regulated? Surely people choose to spend their money. Surely people who choose to spend the money, sorry, Julie, I'm trying to read this correctly.
Do you want me to do that one for you, Cyril?
I think I've got it. I'll try. Third time lucky. Surely people who choose to spend their money on training courses can. So I assume what you're saying here is, why does anyone else need to get involved in the process?
Yeah, I suppose I could have put it like that, couldn't I, really?
Yeah, no, I get you. Well, like I said earlier in this talk, I said over the years, there have been many scandals that have resulted in people going to jail, scandals that have resulted in people losing hundreds of thousands of pounds. Getting into property investment, it's a big commitment. It's a huge financial commitment. And when you don't know anything about the sector, coming into the sector can be quite daunting. There's a lot of marketing out there, whether it be social media, straight from Google, whether it may be. It's hard to differentiate the good from the bad, because it's not always that those with the most glossiest marketing websites that may provide the best education. So we want to help reduce the risk of property education consumers making the wrong decisions, and also reduce the risk of scandals. Next question. Is property education not already covered by laws such as the Consumer Protection or the Financial Conduct Authority? There are certainly existing consumer protections out there, but that hasn't changed the fact that these scandals keep occurring time after time after time. And that's also not helping to raise standards in the industry. So the same issues that are occurring today are the same issues that occurred when I entered the industry over a decade ago. Nothing's changed. And that's why we decided that actually, by creating this form of self-regulation, we can change the culture from within and improve standards from within. There will be some out there that say property education regulation is the way to go, convince the government. Now, I believe that they're not wrong, but that certainly won't happen overnight. So we could be sitting here in another 10 years having exactly the same conversation, because property education is just not the top of the government's list right now. I assume right now they have more important things to think about, like maybe COVID or Brexit or a few other things, and that stuff could take a while.
Or obviously they're politicians running amok as well, don't forget that.
That's correct. So Julia's asked me a personal question here, personal in the sense of my opinion, which is, what's your opinion in regards to what makes a good property educator? I did have to give that a bit of thought, actually, because I have a lot of friends now who are property educators, And I've only bought a small amount of property education in my past. I'm trying to think what made me purchase that education before I did. So the things that I came up with were a good property educator should be someone who has experience in what they're teaching, very important, and can evidence that experience. They should understand how to deliver content to the consumer in a digestible manner. So it's not just having the experience, because you could sometimes have somebody who's got great knowledge about a particular topic, but it's just not a great teacher. And that could really take away from the experience. Someone that allows the consumer to make an informed decision before parting with their money. So someone who's given them enough information for them to weigh up even potential alternatives to a certain degree. We're not going to ask too much from our educators, but they need to be able to know that if they spend their money on this, this is what I'm getting for that money. Ideally, no more, no less. They should be clear about their money back guarantees and their terms and conditions. Very important, because time and time again, I hear that people go into these property education courses, maybe they had a slightly bad experience and they have no idea as to where they stand in regards to potentially getting their money back, or what the terms and conditions of the operator, what their terms and conditions are. Julie, does that answer that question?
It does, yeah. I thought that one was going to stump you.
Try harder.
I will next time, absolutely.
Next time. Okay, so the next question is, if somebody wants to look into property education because they want to learn, what should I look for in a trainer? Oh, is that the same question?
No, not really, because the first one was kind of your personal opinion on it. But if somebody is looking to get into education for the very first time,
I got you. So I asked a question, but I've got the answer there. So I said again, it's evidence that they have experience in what they're teaching over an extended period of time. So if I want to learn about commercial property, ideally I don't want to be learning from somebody who's maybe just bought one commercial property within the last year, because they're not really going to be experienced into all of the potential pitfalls, things that I should look after. You want to learn from somebody who can help you avoid mistakes. And every now and again, someone just gets lucky. If I've just been investing for 1 year, I may have got lucky with my first property. You normally, after 3, 4, 5 years, you've got a bit of experience behind you. You also need to be able to carry out due diligence on the individual. Very important. So looking at things like Companies House, looking at the status of their companies and the directors involved, Googling online. Google searches are fantastic, you know, and don't just go 1 page deep, go 5 pages, go 10 pages if you can. Ask for opinions from unbiased parties. So speak to people who potentially know this person, speak to people who may have had dealings with this person, try and find out information about other clients that they've had, and see if you can get opinions based on, well, unbiased opinions is very important. I would say do not go on the person's Facebook group. If they've got a group which is administered by them, it's more than likely that those people within the group are singing from the same hymn sheet 9 times out of 10. So try and look outside of the initial herd. Next question is, there is so much information available readily on the internet for free. Why do you think people fail to do the research themselves and prefer to pay a trainer to tell them what I can do for free? So I've said that I hope this is, my explanation here is not too simplistic, but I use the analogy of learning to drive. So when I first learned to drive, I don't know how it's changed now, you know, I've got a few years behind me now. I had to learn my theory test, and they gave me a book, or I had to buy this book. I had to read it and then go for a theory test. After learning all the theory, that didn't mean I could drive. I still had to take part in 20 or so lessons, maybe slightly more than that, where I was out on the road learning how to drive. And you can only get that through the experience. So the question you have to ask yourself is, would you prefer to learn by yourself, and many do, and potentially go through all the pitfalls by yourself, or would you prefer to learn from somebody else's experience? Now, I'm not going to say there's a right or wrong way, but if you choose to learn from somebody else's experience, you should be given the best opportunity to do so in such a way that you don't waste your money picking the wrong person.
Perfect. I've just had a question come through on the chat, if I can throw that into you, Cyril.
Please do.
What about an approved qualification system to demonstrate to a third party that a particular level has been achieved to show to lenders, etc.? So the trainee gets a certain level of qualification, like we see for ALA, you get level 1, level 2, level 3, etc.
Yeah. So that person's actually quite advanced with his thinking. That's Chris Davey that said that, isn't it?
Yeah.
It's a very, very good question. And now, so when you're building a business, or when you're building an organization, you need to start somewhere. And where you start is not necessarily where you're going to end up. So in my mind, it would be ideal that we end up with a basic level of accreditation for people who attend certain courses. So when you're going to get a HMO mortgage, if you say that you've been through this qualification that's recognized by the industry, recognized by the lenders, maybe you get a low interest rate. These are the things that can happen, but there needs to be a base level first. And that base level would have to start, I believe, with self-regulation of the industry, a common code of practice, terms and conditions, and money-back guarantees that are transparent. I can actually see what's going on here. So shall I read out this question, Julie?
Oh, yeah, of course, sure.
Actually, no, Julie, it makes it interactive. You read it out, please. Go ahead.
But at least it's not like last week with Mark Alexander. It wasn't even my show anymore. Do you know what I mean? He just took over.
I'm happy to share. Go ahead.
Yeah, so they have CPD points. What about that as a system?
Again, somebody who's thinking quite advanced, because I was actually in conversations with a CPD operator last week, and they were very interested in what we were doing and said, is there a way in which we could potentially look at introducing CPD points into our accreditation scheme? Now, this is something which I actually do favour, and I think most of our educators will favour too, because it would add more value to their education too. So certainly it's something which we'd be looking at in the future, but first things first.
One step at a time, eh?
Excellent. So as we still have a few more questions here from Julie.
Do you want me to read through them, Cyril, for you?
Yeah, you can read the next one. So we're on the how will you question.
Yeah, how will you be able to tell if a trainer is a poor trainer, or whether it was just the attendee wasn't then proactive with what they learnt on the course?
Okay, so this goes back to one of the earlier points that I made. It's not really the P's remit to tell you who's poor and who's not. It's to tell you what standard of accreditation they've reached, what they've done to go through the accreditation. So if it means ensuring that you know that they've gone through a 6-month probation period, and that 6-month probation period is after they submitted their application to become accredited, it's going to be publicly announced. And during that period, if there are many people out there who have grievances with this person, and they can legitimately prove that they had received education with this person, that probation period is going to shed some light on that. So if there are many people who do not think that the education that's been provided in the past by this property educator is suitable, we're soon going to find out. And that will feed into our decision making when whether or not we decide to give that person full accreditation.
Fab. And following on from that, if you find that one of your accredited trainers, for example, has done something that would be technically sort of against the rules, is there any kind of process, like a grievance process or something, that a trainee could come back to you with and say, look, this trainer didn't do what it said on the tin?
Well, this is why I thought this conversation or this platform would be apt, really, because having Sean Hooker in the room, who I believe Sean's official title is Head of Redress. So the Property Redress Scheme, we wanted to make sure that there was an independent body dealing with complaints, because we didn't want anyone to think that it was Cyril and his team making decisions about who's right or who's wrong if a complaint was raised. And the Property Redress Scheme have a fantastic reputation in relation to dealing with such complaints. So they have adjusted their complaints handling procedures to be able to cope with complaints that come from property education consumers. So if you do have a complaint and it's fed into the Property Investors Bureau, if it can't be solved by the Bureau, it goes straight to the Property Redress Scheme, who will take it through their complaints handling procedure. and they will come up with an independent resolution, an independent conclusion to the complaint.
Brilliant, fantastic. Yeah.
Okay.
And my final question is, how are you going to get the message out there? Suppose with everything, you know, we need to get the ball rolling, and we need to make sure that everyone knows this is happening. Obviously, I'm doing this on Zoom with you this evening, and I know that you've been across some other platforms as well, networking. But obviously, it's a big message to get out there. What is going to be your way of getting it to ensure everybody on every level knows that this accreditation scheme is available?
Okay, so another very good question. Now, I'm a firm believer that when you produce a quality product, it makes it easier to find because people speak about it. In addition to that, I've actually been, well, the team has been quite restrained with trying to get the word out there just yet, because we're of the firm belief that you need to make sure that the system is right before taking on many applicants. So we've been quite restricted in relation to what we're saying to the media right now. Although we did recently release an article via Property Industry Eye, and we got quite a lot of feedback from that. I believe we've got 7 or 8 different trainers trying to apply off the back of that. We have taken on our first few applications. Part of the result of putting the article out was that we had one education company who contacted us and said that they want to sign up all of their trainers, and they had 50+ trainers. So yeah, exactly. So I'm not worried about getting the word out there, because in addition to that, we've got quite a few sort of influential industry figures who would be happy to spread the word. Lovely people like yourselves who are staunch advocates of it, which is fantastic. And there's a number of things going on in the background, which means that we're not worried about how we get the word out there. We're more concerned about making sure we get the scheme right. Now, that's not to say that it's going to be perfect from day one, but we need to make sure that it's got enough in it that we can pivot where needed, adjust where needed, and continuously improve it. That's the main area that we're concentrating on at this point in time.
Brilliant. Brilliant, thank you. That's me all out of questions, I'm afraid, Cyril. I tried my best. Has anybody else got any questions for Cyril this evening on the chat for us, so I can get those out to him? Or is everyone gone quiet on me again? I think you're right, they've all been in the sun with their beer with their 6 people, haven't they?
That's good. Well, no, Julia, I'd like to say thanks for giving me the opportunity to take part on this platform today. If anybody does want to find out more information, what I'll do is I'll just put a few links into the chat area. I think, can you see that?
Yeah, that's come up.
Lovely. So if you want to send us any questions, you can send it to the email info@pibuk.org. Thanks, Chris. And the FB group. So we do have a Facebook page, which is fb.com/PI Bureau. And then obviously the website, pibuk.org.
Fantastic. Thank you, Cyril. Thank you so much for that. It's really, really helpful. And obviously, oh, what's that? Oh, lots of people saying thank you. Well, they were listening then. That's good.
They're still there. Thank you, Dylan.
Always a good thing to make sure they're awake. Fantastic. And obviously, thank you, Sean, for your presentation at the beginning. I'm going to bring the meeting to a close now, if nobody else has got anything they wish to say. Next week, which will be the 9th, we will have advanced tax strategies for property professionals looking for a tax-free income. Goodness, you can tell I read that verbatim, can't you? Okay, and that will be the same time. It will be 7 o'clock next Tuesday, and obviously the links will go out as normal, and it will be on Zoom, Facebook, Meetup, newsletter, you name it, you'll find it. So again, thank you so much to Sean and Cyril for this evening, and thank you guys for coming along. I couldn't do it without you. Thank you very much.
Thanks, Julie. Thanks, everyone. Bye.